All right, good morning, everyone. It's good to see everyone. I recognize a few Minnesota faces in the room. All right, so I'm Jamie, and this is Heather, just to make sure and clarify. So I'm going to give the quick spiel. Just Minnesota received a grant, and so when we do these presentations, we have to give you the quick. This training was supported in part by grant number, and I won't read it. Elder Justice Innovative Grants awarded in 2021 for improving guardianship from the Administration for Community Living, ACL, U.S. Department of Health and Human Services. Grantees carrying out projects under government sponsorship are encouraged to express freely their findings and conclusions. Therefore, points of views and opinions do not necessarily represent official ACL and DHHS policy. So here's the agenda of kind of what we're going to cover this morning. We have a lot to talk about. I will be covering the conservatorship side, and then Heather will be covering the guardianship side. We're going to talk a little bit about our grant and some of the fun, exciting things that we're doing with those funds, and our new complaint process, which is also part of the grant. Before I move into conservatorship, I let Heather know this morning that we probably should have added a slide for the non-Minnesota people. I've been doing this so much for Minnesota groups. So Minnesota is a unified court system. We have 10 districts, 87 counties, over 100 court locations in the state of Minnesota. And then also for term purposes, we use conservatorship for the money side and then guardianship for the personal well-being side. So I know a lot of states are just guardianship, but we have the two terms here in Minnesota. All right, so we will jump into conservatorship. So first slide is stats. You'll probably get a lot of stats out of me today. I'm an auditor. I love stats. I love numbers. So that's what's you're gonna get out of my slides. We're gonna talk about the conservator account auditing program and then the conservator account review program. I'll talk about both separately. Also in Minnesota, we love acronyms, I'm sure like every other state. So you're gonna hear CARP, CAP, MMC a lot come out of my mouth. So Minnesota courts oversee a total of roughly 5,400 annual accounts, conservatorship annual accounts, and that's $1.2 billion in bondable assets. So that does not include the real estate assets. In fiscal 2022, CAP audited over 1,000 annual accounts, and CARP reviewed over 3,200. Then CAP and CARP, and I'll talk more about this in coming slides, but they reviewed over 1,000 inventories, and then we've also added account summaries, and I'll talk more about that too in a couple slides, but we did almost 1,500 of those in fiscal 22. And then our operating budget, which a lot of people are usually very interested in, is of $1.5 million. And then the bulk of that is payroll. So CAP, what is CAP? Our auditing program. So this was established in 2012, and it's a statewide program that audits the conservator accounts on behalf of the state of Minnesota. We use our My Minnesota Conservator MMC program, and the program is utilized also by the conservators. The program allows conservators to enter their annual account information as well as their inventories, and then we use the system for our audits and our reviews. We maintain a helpline. Her name is LaVon, and she does a wonderful job. She's part-time, and then we also provide best practices and some consistent oversight with courts if they need assistance, and then guardians, conservators, different partners and other groups if they have questions or concerns. Our team is made up of one supervisor that reports to me, and then LaVon, our self-help person. I have 8 auditors. There's 2 that are part-time. I have a lead and then also a temporary that is helping us. We have a backlog in our cases that we're working through. Just some criteria on the auditor. We want a 4-year degree in accounting-related field for our audit team. The auditors look at the first annual account, and then they look at every 4 years after that. So 5th, the 13th, and then we also take referrals, whether that's from the courts or if a potential complaint comes through, or if the judge says, no, I want this audited, then we will audit it outside of that timeline. We also then CAP took over the inventories. So I mentioned earlier we had the CAP and CARP. We had CARP reviewing inventories, and then we moved that over to the auditors because we felt that it was more in line with looking at the inventory that comes in with that 60 days and then doing the audit of the first annual account. So kind of that similar eyes. We also added the inventories roughly in 2018 when CARP started, and I'll talk more about that too, but we felt that most of the errors that were coming through was that inventory. They weren't starting with the right balance. So looking at the inventories gets the conservators started on that right foot, and the balances are then correct. CAP writes a report at the end of all their audits. And then just noting here too that the final accounts follows this above criteria. So if it's a final account, whether they're being restored to capacity or person subject to has passed away or a successor conservator is being put in place, that final account follows these guidelines. We don't have special exceptions. The auditors request 100% documentation, all invoices, receipts, anything, tax documents, real estate information, so 100% of whatever is in that annual account that's been reported. When they write a report, they assign levels. So the levels are up on the screen. Level 1 is there's no issues. Level 2, there's some minor accounting problems. Level 3, there's multiple accounting problems. Unfortunately, a lot of our conservators, they don't have an accounting background, so we do deal with a lot of just issues, mistakes, wrong categories, those kind of things. And then level 4 is there is a concern of loss. We're concerned of theft or the money went missing somewhere. Level 5 is they didn't comply with the audit. They didn't provide documentation. Some, maybe all. And then level 4 and level 5, we mark those judicial review necessary. So we want the courts to call a hearing on those 2 levels specifically. This gives you an idea of where the levels have fallen. This is fiscal 2022 numbers. So in my notes previous when I've given this presentation, I will tell you that level 3s and 4s have dropped, that it used to be like 25% between that level 3 and 4 combination. Now it's dropped to 21. However, I was just talking to my auditors over the last week or so, and they're all telling me that they've seen more level 3s and 4s in the last couple months, and it's terrible. So we don't know what's happening, if it's people are low on cash, prices are going up on things. They've also said that the conservators aren't even trying to hide it. They're just spending it. So we don't know what is going on there, but it's concerning that those level 3s and 4s are increasing and going back up. So then CARP. CARP is our Conservator Account Review Program. We implemented CARP in 2018. And so before we implemented CARP, for the Minnesota folks in the room, you know that each court location kind of got to do their own reviews of these accounts. And we have 87 counties, over 100 court locations. We had probably 87 different ways of doing those mid-year reviews, the in-between years of those audits. So we created a centralized monitoring of the in-between years and pulled that out of the courts. I think they're pretty happy about that the specialized team took that work. They also use MMC, so we enhanced MMC during that time to create a queue for our reviewers. And so the team is made up of 1 supervisor, 7 reviewers. That includes a temp and then a very, very part-time reviewer. This position requires a 2-year kind of financial related degree or experience. A lot of our team comes right out of the courts, which then they have probate experience, and that's great. They basically review all the in-between accounts of an audit. So if it's not up for audit, then they're reviewing it. They also review 10,000 or less bondable assets outside of that first year annual account. And then they review any amended accounts. So if an inventory needs an amendment or an annual account needs an amendment, they review those all as well to make sure that they're being done correctly. Because as you can imagine, conservators, even though we provide very, very clear directions in the reports of exactly what adjustments need to be made, they usually make mistakes. So then we have to go back and help them with those. They also, CARP writes a report, and they do not assign levels. So that's one difference there. And then they write a CARP account summary report. So that is when the account is going to be reviewed by the judge, whether it's 1 through 4 or 5 through 9. They put an account summary together of all of those years with all of the findings, bondable assets, recommendations, anything the conservator might have not done over the last 4 years, and they put that together in a nice kind of couple-page document for the judicial officer. This is just to give you an idea of some of the goals, the performance goals for the work that they do. So an inventory, the goal is 2 hours. The inventories have been coming in pretty messy as well, so they've been taking a little bit longer, but then it gives you an idea of the number of hours that are spent by the auditors and the review team on the different items, different levels, and reports. So red flags, our system MMC has automatic red flags that are triggered in our system. We actually have 27 red flags. I don't have obviously all 27 listed up here. I just put out some of the maybe more common red flags that we see that will be populated in the system. But gifts, charitable gifts that exceed $1,000, as you can imagine, we get a lot of, well, grandma wanted to gift me 10 grand. And so that would get a flag. Loans, debt, miscellaneous transactions, round numbers are a big one. If you have more than, I believe it's like 10 transactions that are like a 00 or a 50 cents kind of a thing, then that triggers. They're a great thing to have. They kind of give that flag for the auditors and the reviewers. However, we are at the mercy of what the conservator is entering, so it's not always accurate. Sometimes the flag doesn't mean anything, but it's a nice thing to have in the system. Level 4, concerns of loss. So everybody likes the real examples, right? The real war stories that we have. So I'm just going to list off some, which the slide has some of the high-level examples, but I have some specifics that I thought I would share today of what the team has found in the past. So you have one example of approximately $170,000 was paid for attorney fees, and the person subject to started out with about $200,000. That was because the family was fighting over whether she should be under conservatorship or not, and they pretty much depleted all her funds before she was restored to capacity. She did not need to be under conservatorship. Conservator accidentally paid for a trip to Vegas. Well, that was in there. Conservator paid himself $75,000 in fees, never paid the care facility, and then left the state, did not comply with the audit. There was a case where a conservator transferred $500,000 from her parents' funds to her failed business account. Conservators borrowing money from minors, we see that a lot, making updates to their homes, buying homes in the minor's name when they get an inheritance. Conservators purchasing SUVs and pickups when the person subject to does not have a driver's license. CDs being cashed out and the money goes to the conservator's pocket, so that's why we always ask for those statements to make sure they haven't been cashed out. That's something that can go missing. Conservators paying for their own health insurance premiums, utility bills, person subject to being evicted from a care facility because they reported in MMC that they were paying the bills to the facility, but they were really not. So that person was evicted. Conservators making payments to themselves and altering receipts. It's a big one. We figured out that Amazon receipts are really easily altered, which is really unfortunate. So we had one once where they were buying things for themselves and then trying to alter the receipts that they were buying it for the person subject to. And I believe it was her father. She was buying women's shoes, things like that. So she missed a few and we caught that one. And then paying for the same expenses out of Social Security. So that's something that's federally mandated and monitored, but we generally will ask if they give it to us. we want to see that Social Security as well, because they could be double dipping and paying out of one and pocketing out of the other. Some common issues that we see when we're doing our audits and our reviews just from conservators, not responding timely, so that judicial review necessary because they're not providing documentation. We give usually a couple-week extension when they ask. I mean, we want them to comply. We want them to give us the documentation if they can. It's a lot more work, and then we're seeing that account a couple times if we see nothing, do a non-compliance, and then it's shocking how when the judge will call a hearing, then they want to comply a couple weeks later, so then we're seeing that account again. Not providing all the documentation. I didn't know that I had to provide the tax documentation, real estate, that type of thing, so it's a common issue. Or they are supposed to review a video before they're granted to be a guard or conservator, and they'll say, well, I didn't know I had to keep receipts. Well, it clearly states in the video like 5 times that you have to keep receipts, so that's a common one as well. Conservators not obtaining court approval for large expenditures, so that's something they should be going to the court for, or disposing of personal property. Again, that's something that they also need to get court approval. Not adequately bonding conservatorships, that's also a problem. The statute states that if it's over 10,000 bondable assets, it should be bonded, but we do have an issue where not all judges want to be bonding those accounts. And then also personal property not being properly valued in the system. Sometimes they're overvaluing it, and then they're supposed to be bonded on that. So it's important for them to be properly reporting those assets. Spending funds past the date of death, that's another big one. In Minnesota, the conservatorship ends when the person subject to dies, but they'll continue to spend those funds. They need to be going to court and talking to them about, okay, what happens now? Can I continue to spend? Can I pay the funeral expenses? Those kind of things. As you can imagine, we've had issues where grandma dies, so then the granddaughter continues to spend, well, now it's my money, and then they just spend. So that's another issue that we see. Transactions and expenses just not being properly reported, or in incorrect categories in MMC, so that's another common one. People like to select miscellaneous or other commonly, and then I mentioned earlier amendments that are not reported correctly. All right, so My Minnesota Conservators. So I'll just talk about this briefly. This is our system that we use. It's an online reporting application that allows the conservators to report, and then this is what our auditors use for their reviews and their audits. They are responsible for managing their own queues, and I do have a slide that I'll just roughly show you a screenshot. We built MMC with a grant from the State Justice Initiative, and I mentioned the conservators submit their annual accounts and inventories. The reports are filled out in a computer browser. You can use your smartphone, but it's not ideal. We built MMG differently. MMG, you can use your phone. It's pretty fantastic. So that's something that is on our list to look at if we can adjust that. We do know, to conservators, though, that this is a complicated system. You really should be on a computer. You're entering transactions. So we'll see how that works out in the future if we can make those changes. The system sends emails and notifications to conservators when their reports are due, so that's a nice feature. The system was launched in 2015, and then it is mandatory that conservators file their accounts and inventories in MMC per court rule. So this is just a screenshot of the homepage on MMC. It gives you, it's hard to see, to give you an idea of what it looks like. There's a tutorial in the green writing over there. It's about a 5 or 6 minute video on how to log in and get going in the system. We have lots of videos on our court website, YouTube videos. They do need to be updated, but kind of a bunch of how-tos, which are wonderful for conservators. And then this is the queues. It gives you, this is my queue. Actually, I don't get to do any audits, though. I don't have time. I'm very thankful for my staff. But have the audit queue and the review queue. There's the hearing prep queue, and then it has the names, case number, when it was submitted, and then it has the assigned to. So you have the assigned, you can assign cases to a specific auditor or reviewer. Otherwise, our auditors and reviewers go in, they assign their own cases, they manage their own workload, and then when they assign a case, it goes then into their queue, and then they manage that work. And then you can see the flags also on the far side. And then this is just a screenshot of our webpage, so it gives some support and links for MMC. Like I said, we have our help line. Levon is wonderful. People will call for all sorts of questions and concerns with the system. But this also gives just some support on how to set up the account, frequently asked questions. There's training out there. It's links to all the videos. And then we have self-guided training as well that conservators can take that's out here. So I'll just note before I turn it over to Heather that we're just showing some screenshots today, but anyone that's not from Minnesota that's interested in seeing the systems or having a demo of the systems, we're happy to share. We have two wonderful people that are BAs that will kind of give you this is what the conservator sees, this is what the guardian sees, this is what the auditor sees, and then we also will share the code too. So our contact information is in the back, but I just wanted to throw that out there as well, that we just have screenshots today, but that is an option if anyone from other states is interested. So, all right, turn it over.
Okay, so guardianship. So as Jamie said at the beginning, guardianships are protection of the person as opposed to the money. And Minnesota courts oversee approximately 34,000 guardianship cases total. And we have both professional and non-professional guardians. 10% of our caseload is they're professionals. They work for an agency or they own their own company and act in a professional capacity. Otherwise, the other 90% are non-professional. So often it's a family member or a friend. So we were doing all of these great things with conservatorships and the auditing of those accounts. And as you saw, MMC went into or was implemented in 2015. And so what are we going to do about guardianships? So there was a need, obviously, to take a look at our guardianship cases and see how we can improve the processing of those. So probably about 2017, 2018, the branch started looking into having something similar to MMC for guardianship. So My MN Guardian, MMG, came into being. And so MMG is an online tool developed for court-appointed guardians to electronically submit their annual personal well-being reports and affidavits of service to the court. So again, the judicial branch got a grant from the State Justice Initiative. And so when MMG was developed, again, we have another acronym, Personal Well-Being Report. Those are our annual reports submitted by the guardians. So we call them PWBRs. They can be filled out on the web browser or with a handheld device, as Jamie mentioned earlier. Also, guardians can receive email or text. They can sign up to receive both or either to have a notification about the due date for their reports. MMG was launched in the fall of 2019, and currently using MMG is not mandatory for guardians, but there's a potential rule change that may be going into effect possibly this summer that will make MMG mandatory, which will be helpful because then we can have guardians all reporting the same way, which will help us look at those reports more consistently. So the benefits to MMG are both to guardians and to court staff. So for the guardians, the system is meant to be easy to use. It's an interview-style questionnaire. They get the timely filing reminders, like I said, email and text. The addresses and reporting period automatically populate for the Guardian into the reports. They don't have to type out their address. Another piece of that is that if they have an address or phone number or email change, they can submit that through MMG, and then once it's reviewed by court staff, it will be accepted, and then what's in MMG will be sent to what's in MinSys, our case management system, or our case information system. So the two things are kept in sync. The addresses and information in both systems are in sync. The MMG allows the professional guardians to keep track of all of their cases in one place, so they can look at what did I say about in the report about this 5 years ago. If they've been using MMG, they can look it up. And so it maintains their past personal well-being reports. Then for court staff, this automates the annual review process. So rather than getting a personal well-being report in paper and file stamping and imaging and putting it into our case information system, it comes into the court queue and they accept it. Then there's some other steps after that, but it automatically, the system through an integration automatically adds what we call a case event, and it adds that to our court information system and also attaches the image of that document, a PDF of that document, into our case information system. And it also decreases the need for manual tracking of these, of whether or not they've been filed. So this is really hard to see, I know, but this is what the court staff would see when they are logged into MMG. You can see that along the left-hand side, it tells there's a number at the top that says how many are in their queue, and court staff are assigned based on their counties or districts. So that's all on the left-hand side as far as filtering. By that, they'll only have access to the county or district that they're assigned to. And then we have the person subject to guardianship's name, the county that it's in, if it's an amended or an original personal well-being report, that's in the report type. The report number is how many reports have been submitted, basically, since MMG started. So if they're in their third year, it would be report number 3 is coming in. The report due date, so that is basically every year on the anniversary of the letters being issued for the Guardian. So the system keeps track of that. And it indicates whether it was co-signed. And we even have a system for that lets us know when it was filed in paper. It integrates back into the system. So it keeps the date so that when eventually they do start using MMG, if they're not yet, it will be on the right date, or that's, as long as everything is entered correctly. And then we get the date that the report was submitted. So this is what a professional guardian might see on their end. You can see that it tells them the due date, it's got the case number and the person subject to guardianship's name, the reporting period, and they can filter, like they can say, what do I have due in the next 30 days? What do I have due in the next 6 months? So they can filter, the Guardian can filter to show which ones are coming up due. We also have a color key at the top, so if it's red, it means it's past due, and yellow means it's just due right now, and then some, if it's not due yet, then it'll just be kind of the gray color. So here then, you can see they just click the button to complete their well-being report, and that brings them into the interview process. This dashboard also keeps track of whether or not their affidavit of service has been filed yet or needs to be filed. So this is just a nice little one-stop shop for the guardians to go to determine what they need to get done and when. And then there's others, so there's reports due. There's also reports history. That's the second tab under my dashboard. And that is where they can go and see the reports that they've already submitted in the past. Cases will be a list of all of their cases that are assigned to them. And then notifications would be any notifications coming from the court. So, for example, your affidavit of service is due, so it keeps a history of all the notifications that have been sent to the guardian. And then employees, only agency administrator type roles have that, but that way if you have, we have some large agencies in Minnesota that they have, many employees, and so the agency administrator can go in and assign out the cases to the different employees. So here is their cases. So like I said earlier, they can keep track of all of their cases. It lists the person subject to guardianship's name, the case number, the next reporting date, what the status of that next reporting date is, and the date that the guardian was appointed. The system keeps track of all of that. And this is a slide that shows kind of the support we have on the website, on the public website for guardians. So when MMG was first developed and implemented, we had some live training sessions, and we're currently working on updating those trainings because as part of a grant, we are making a lot of enhancements to the systems, and so we're going to want to redo the whole training so that new guardians coming on board can see what it looks like now. It's a little prettier. And then we also have an external application support team. I don't know if Cindy was in here, I don't know, but her team takes the calls from guardians when they have questions about filling out their reports in MMG. And so we have the resources for guardians, and we have training, and we have a document with frequently asked questions, and we have what we call quick reference guides, or QRGs, that just different various things they can pick. Oh, I want to fill out my report, and it steps them through and shows them screenshots of how they should do that. So we have all of that, and then we also have the Guardianship and Conservatorship educational video, which we're in the process of redoing because in 2020, the legislature changed. We used to call those under guardianship and conservatorship ward and protected person, but now they're person subject to guardianship or person subject to conservatorship. So we need to redo that video with the new terms and some other things that have changed in the meantime. So, as I said, when the personal well-being report comes in, it's pretty easy in the court queue. Court staff just accept it, and it goes into MNCIS. But we also require court administration to do some review of the report. So Minnesota statute regarding monitoring of guardianships is not too helpful. Basically says the court shall establish a system for monitoring guardianships, including the filing and review of annual reports. So that's it. That's what we're told. We're supposed to have a system for monitoring and reviewing reports. So basically, the judicial branch, we got together with different judges and different administrators and determined what are we going to review, what extent is the review going to entail. So right now, in MMG, the personal well-being report automatically has the reporting period for the guardian's name, address, and phone number, the person subject to guardianship's name, address, and phone number, and our system will not let them submit it unless they've answered every single question, and then it automatically populates the guardian's signature at the end. So there's a few things built into the system to make sure we get at least some of the basic information that we need. So the other things that we ask court administration staff to look for are a few areas of concern. And we tried at the beginning when we first developed this process to make what they're looking for as objective as possible so that they don't have to use a lot of judgment. So basically, if the person subject to guardianship, if their living arrangement is indicated as homeless, they're supposed to flag that. and, or if the guardian's describes that the person's mental, physical, or social condition is in such a way that indicates that that person might be a danger to himself or others. If the guardian indicates that there's been no contact with the person subject to guardianship over the last year, unless there's a legitimate reason for it, because sometimes there's just, they might have somebody acting in their place for a year. If the guardian has placed any additional restrictions on the person subject to guardianship's right to communicate with or visit anyone within the last year. So those are the main things that court staff looks for right now. And they can also ask, they can certainly ask the guardian for more information whenever they feel that's necessary. So that's what we're looking for now, but we are in the process of kind of beefing up our monitoring more, and we want to look for additional areas just to dig in deeper into these reports and see if there's other things that we can pull out that we want to look at, because we just want to make sure that these people are well taken care of. And like I said, the statute says we're supposed to monitor and review the reports. So these are some additional items that we're going to be looking for. If the person subject to guardianship has moved multiple times within the last year, we're going to want to get some more information about that. If the person subject to guardianship has received no medical services in the past year, that's a concern. If the guardian indicates there's been no contact with the ward less than quarterly. In the last slide, it was less than a year, but we're going to be changing it to more often. And if the guardian has placed any additional restrictions, we're going to have court staff review for a form of notice of restrictions being filed. So it's just I guess, digging into it a little bit more is essentially what it is. So what happens when they do find something? Court staff is to fill out a notice of personal well-being report review and indicate what they see in the report that they think the judicial officer might be interested in. So they fill this out. And then when it gets referred to the judicial officer they can schedule a review hearing, they can ask the guardian to send in additional information, they can assign a court visitor or a court-appointed attorney to help look into it a little bit more, or they can take no further action. They can determine maybe that it's sufficient, that they have some background information about that case, that it's not necessary to dig into it more than that. So those are some of the items that we do right now. So all of this, as you can see, we're thinking, okay, we need to do more in-depth review of these cases. And there's other things that are just not, we can do better. Minnesota can do better than this. So we applied for a grant, and as a result of receiving that grant that Jamie mentioned earlier, we now have a project that's entitled Advancement of Minnesota Vulnerable Adult Care. And the goal is to ensure that people subject to guardianship and conservatorship in Minnesota are adequately protected and well cared for. And some of the main objectives here, our list is actually quite long, but some of the main objectives are to create a complaint process to alert the court of potential maltreatment, create the capacity to detect fraud and abuse, create the capacity to document and track the information received, and to do some supported decision-making training to all sorts of different groups, court visitors, and attorneys and guardians and conservators themselves. So there's been a lot of training that's been going on as a part of this. And another piece of it is similar to what Minnesota has for conservatorships. We would like to see more centralization of the guardianship review work. And so our branch leadership decided in January 2020 to require each judicial district to have a centralized guardianship unit. And we have 10 judicial districts, and right now, 8 of them already have a centralized unit, but they're not all necessarily doing the same thing. Some do A, B, and C, and some do B, C, and E, and so we want to get everybody doing the same thing. So basically, each district team will have mandatory requirements. There will be certain work that each team must perform in their district, and they'll have specific steps for completing the work to ensure consistency. And then they'll receive statewide training so that everybody receives the same message. So, and this largely comes about because these are some of the issues that we were seeing. Inconsistent review of the reports, so some were looking at some things, but not all of it. Some were really looking into a lot. There were disparate reasons for sending deficiency notices to guardians. There were different rates of referral to judicial officers. This doesn't have a lot to do with the monitoring, but we have processes for filing our background studies are inefficient, and counties and districts are doing them in different ways. There's lack of specialization in these work-intensive and complicated case types. And basically, we have this robust financial auditing system, but we want to increase the emphasis on the protection of the person. So we wanted to solve these problems, and thus we are looking at now having centralized groups. And in addition to having centralized groups, we're going to be increasing the duties, I guess, that come along with guardianship work. So there's going to be more fraud and abuse notification, like I talked about earlier, additional review and monitoring of the filed personal well-being reports. There's going to be follow-up on the notice of restrictions to ensure that they're being filed as they should be. Follow-up when the guardian indicates that the guardianship should be modified or terminated, because quite honestly, the guardians often say in the personal well-being report, yep, this should be terminated, but then don't follow up with anything. So we want to look at that and getting that more efficient. We want to, I guess, upfront, when the guardian is appointed, review for supported decision-making and other less restrictive alternatives. Make sure that those have been looked into because it's required by law. They follow up on other reporting requirements of the guardian and conservator. So they're supposed to tell the court if the guardian has been arrested or has an order for protection, or there's like a long list that they're supposed to let us know if any of these happen. So we want to kind of dig into that a little bit more and make sure that we're getting that information. And we want to monitor more closely a person's progress to restored capacity. This one and the next one are big ones, reviewing for limited powers of the guardian, because there's a lot of angst, I think, about whether or not does this person need a guardianship, or does this person need all of their powers transferred over to the guardian, when there could be fewer powers needed by the guardian, or maybe the person doesn't need to be under guardianship. So we just want to be very mindful of their civil rights being taken away, because oftentimes the judicial officers may feel like, well, it's better that I put them under guardianship and they don't need it than the opposite. But we want to maybe change that mindset a little bit more. So I think Jamie is going to talk more about some of the new and fun stuff we are doing. Thank you.
So yes, with the grant, we also are going to be updating and enhancing and doing a lot of new development with MMC and MMG. Minnesota recognizes, we have some really great tools that we utilize in these two areas, but they could be better. And also more efficient, maybe easier use, and as well as we've had some statute and law changes in the past couple years, and so that's definitely had to change some of the things in the systems. So starting with MMC, we created a new accounts receivable tab. So before, there was no good way for a conservator to report money owed to the person. So whether that, was a court-ordered judgment or maybe rent, any type of like pensions or AHSAs. So we heard a lot from conservators, and of course, it's the conservators that want to do good, right? They're trying to do a good job and report anything and everything that they should and can be. So we heard the conservators loud and clear, and so we created with the grant funds this new whole separate tab in the system where they can report those monies. That went live in November. It was pretty exciting, and then within days, seeing the conservators using that and having stats from that information. So that was pretty great. Also, an emergency conservatorship feature. So right now, MMC doesn't have a great way to track and handle that emergency period. So if you come in and petition for just an emergency and they can grant it for 60 or 90 days, there's rules around those two timeframes. But MMC just can't handle the difference between the emergency and then going into a general period if it kind of goes and then it keeps going. So we want to create a better process in MMC where it can better track and handle that time frame and allow conservators to properly enter any money that's been, changed or transactions and spent during that time period. Background studies, as Heather mentioned, we have a small issue with background studies in Minnesota, and it's not super efficient. So right now, every guardian or conservator is responsible to file that background study within each individual case. And as you can imagine, some of our professionals have hundreds of cases. So we want to somehow hopefully put it on the party record. Heather's going to probably kick me that I'm saying that because we're still working through how is this going to best look. But we do know that it's inefficient, and we want to make it better. So I think that's one way we're looking at is on the party record versus the case, and then that will take care of background studies for all of their cases that they're working in. Collecting additional data. We recognize that we could use some more information on these cases. I often refer to it as the information that's stuck in the petition, because the petition comes in, it's e-filed, and then it's a PDF document, and you can't run data off a PDF document. So somehow pulling a lot of that information out, whether it's age and birth date and powers and limited powers, and is it a full guardian, conservator, et cetera. So we'll be looking at good ways to have that data pulled out so that we can run analysis on how we can better serve these groups. Also enhancing our reporting features. We have some reporting in the systems, but we know that we can have it better, more efficient, so we'll be looking at those. And uploading features. So that's a big complaint we hear from conservators is uploading, and it's slow and it's not convenient. And so looking at better ways to allow conservators to upload those documents into MMC. And then the level 4s, I often will get a question from an audience like this or out at a conference, what happens after the level 4? And do you track that? And that right now is a manual process if we try to track. And what did the judge do? What did the judge court order? Were there criminal charges? We have no ability, except manually right now, to go back and look at all those cases individually, and we just don't have the capacity to do that. So we're looking at ways to make that more efficient, and then maybe have the ability to run reports for that information so that we know what did the judge do when they saw that level 4 concern of loss and fraud report that came through from the audit team. Then on the MMG side, there's some similarities. We have the reporting features, the additional data, and the background study. We also are looking to improve some sorting and filtering in the MMG system, improve help text for the guardian, so that's something that we're also working on. Ensuring that reports errors are kind of removed behind the scenes so that guardians aren't not seeing those errors as well. And then also some enhancements around serving the person, affidavit of service, notice of restrictions, possibly including that all within the system. And then looking at some new integrations and co-signing feature that also has been a struggle for the guardians. If there's 2 or 3 guardians on a case, they struggle with that co-signing. And so we want to make that easier and more efficient for our guardians. The one thing that it's at the bottom in small print, that I'm most excited about that we're doing with these grant funds is if a guardian or a conservator has been removed for cause. So they were abusing the person, they were spending all their money inappropriately. We're going to flag that guardian or conservator so that way they're flagged in the system, and then judges can pull them in for a hearing, talk to them about that case, because they may be in Hennepin, but they've also got a case in Dakota and Ramsey and every other county in the state of Minnesota. So we want judges to be aware of those concerns, be able to bring them in, talk to them. It's in statute that they're supposed to report it to us if they get removed for cause, but we don't always trust that they're always going to let us know when they're removed for cause. So that's also an exciting feature that we're adding. And then the complaint process. So this started and got up and running July 1st or June 30th when the order was signed by the chief. Minnesota recognized that we needed a better way for interested parties to complain to the courts if they had a concern about a guardian or a conservator. So we created this process, and because the statute states that an interested party can complain, but we got a lot of questions from stakeholders and outside, how can we complain? So we created this process. We have a form that's on our website that you can go out, you can print and fill out, you can mail it in, fax it in, email it. We have a hotline. Our complaint examiner is Mark Mested, so he has an email that it will come into then, and he answers the hotline as well. If a complaint is filed on a particular guardian or conservator, the complaint is then sent to them. They have 21 days to respond, so they are informed that a complaint has been made, and they can respond to that complaint. Once the response or that 21 days is up, because not all guardians and conservators choose to respond, then he will then start his investigation, reviews, additional documentation. He does do a lot of preliminary in that time frame, looking at the case, what's happened up till now. Has the courts been doing anything with this case, even though someone has complained? Is it being resolved possibly on its own? Do I need to be involved? Those kinds of things. Once he has conducted his investigation, then he files a report with the court, and it has the findings, a lot of background information, the complaints, whether they're substantiated or not, whether he found proof of the issues, and then kind of a conclusion for the court where he's come to. And then at that point, the judicial officer can call a hearing, bring the guardian conservator in, remove. The complaint examiner does not have authority to remove anyone from a case. That is the JO's, obviously authority and discretion to do so. And then also we're looking at different referrals when these complaints come in. We're starting, unfortunately, to see complaints coming in that are not about abuse or fraud or necessarily violating the rights of the person. So where should those complaints go? Should they go to APS, Adult Protective Services, or DHS, or just another different partner agency that can maybe better handle that particular complaint? And then so far to date, we do have 56 complaints. And yes, I said we started July 1. So that is a lot. He's very busy. I will say some of those have been closed. I believe we've had 10 that they've closed on their own. And then also some are duplicate. So he will receive multiple complaints on one particular guardian, which is also fairly concerning. This is just a resource page, so if you have access to the PowerPoint, there's the link to click on, and it'll take you to duties, tip sheets that we offer for guardians, conservators, and the different trainings that we offer. And then Heather and I left plenty of time for questions at the end because we anticipated some. And then I also, like I said, our contact information. So if anyone is interested in a demo or hearing more or wants to schedule a meeting with us, we're happy to do so. So, questions?
If you could wait till I bring you the microphone, just for the people online. Are there questions from the people online? Okay. Anybody have questions?
Well, first, just terrific work you've done here. It's really impressive, and so thanks for sharing. I recall under the SJI grant that this model could be replicated by other jurisdictions. I wanted to ask, did any other states actually follow up on that? Is it something that is deployed in other places? Thank you.
So I believe we've shared, I don't have the exact number, I think it's 11 different states or counties that we've shared the code with. And I know that one state for sure, I think it's Illinois, was able to replicate the MMC system and had it up and running. They did run into one bump though where they don't have it integrated with their case management system. So it is a standalone system where MMC and MMG, they both integrate with our case management system. So when they're hitting that submit button, those documents are automatically going over.
And what case management system do you use?
We're Odyssey, so.
Do you get referrals from your job and family services, or are these just all coming directly through the court? And to what extent are you able to monitor those referrals once they come to the court?
So specifically like for just audits and reviews or personal well-being reports, we don't generally get a lot of referrals. Most of the referrals come from court administration or from our JOs. They may let us know, we know that this is up for review, but we really want it audited this year. But in our complaint process, we're seeing a lot of referrals coming in from those types of groups or medical facilities, caseworkers, adult protective services. So we are seeing that and we are tracking it right now. Again, that's a manual process as well. Correct, yep. Not right now, but that's something that we're looking at also doing with the grant funds.
I asked that question because it looks as though most of the ones that you have come through the court, or people are engaging in that process and they request, and there's a lot of fraud out there for dependent children and senior citizens with people operating in that capacity, but not officially. You don't, and I would think that would come from juvenile and job and family services. So in the future, you would be expanding to encompass that perhaps?
Correct, definitely looking into that.
Great job.
Thank you.
Any other questions? Nothing online? Okay. Okay. Well, thank you. This was really educational for me. We're in the midst of working on our conservatorship and guardianship oversight, so it was very helpful.
All right, thank you.
Thank you.
Just a reminder to make sure that you rate the session and then also go down to the speakers and rate the speakers as well. Thank you for coming.